Hey, everyone, that's on. Thanks for attending today's webinar, Understanding the FCC's Proposed Rules for Text Messaging and Lead Gen. We're just going to give participants here a few minutes. We can see them trickling in. So we'll go ahead and get started on the substantive content here in about a minute or so. All right, well, just as a little bit of background, I think most of you attending are probably now well aware of the FCC's Notice of Proposed Rulemaking. We're going to get into all of that here in a minute. It's been about a week and a half, time to digest. We are going to go through the ruling, talk about its impact, both in terms of lead gen, in terms of texting, text blocking, and talk about the implications of that and get to some of the questions that have been pre-submitted. If you want to submit additional questions during the webinar itself, you can use the question and answer box, and we will get to those at the end. We don't anticipate this taking a full hour. Depending on how many questions we get, it could take a little bit longer, but really just wanted to make sure everybody's on the same page with this and answer as many questions as we can during today's session. So with that, my name is Nick Whisler. This is Josh Stevens, partners at Mac Murray Shuster, and we will be hosting today's webinar. General disclaimer, right? We're not providing legal advice, providing information. Any answers that we provide to the questions is not legal advice. If you need legal advice, please feel free to reach out to us or to somebody else who would be happy to provide it.
All right, thank you, Nick. And of course, we obviously would hope that we'll be your lawyer, and for many of you on the webinar, we probably are. But let's dive into the agenda for the March 16th FCC open meeting. The first item is what we're going to talk about today, which is a report and order and notice of further proposed rulemaking relating to text and also relating to the lead gen loophole. That seems to be the thing that's caught the most attention, and rightfully so. And so that's what we really want to focus on for today's session. But there are a few other things on the agenda. One is a 6 report and order and notice of further proposed rulemaking related to stir shaken and caller ID authentication. And just at a very high level, this report and order would establish certain robocall mitigation plan enhancements, as well as an expedited procedure to remove filings from the robocall mitigation plan database and a few other items. Obviously, if you have questions on that, we're happy to address those after the webinar. And there are a few miscellaneous items. If you're interested in satellite regulation or how they test radio equipment, you can stay for that part of the FCC open meeting on March 16th, but we're not talking about that here today. So let's talk about texting and what the report and order would do with regard to text messages. The first thing is it establishes a mandatory blocking of texts that are highly likely to be illegal or that show up on a do not originate list. And so if you think back to when the FCC was first starting to regulate caller authentication for voice calls, one of the first steps they did was they allowed carriers to block calls that were highly likely to be illegal or that were on a do not originate list. They're taking that concept and they're expanding it over to text messages. So, for example, if a number that a text is purporting to be from is unassigned or unallocated, then there should be no text messages originating from that number because no one should have that number. Also, a subscriber could put a number on the do not originate list and say, I'm never going to send a text message from this number, so don't allow texts that are purporting to be from this number. So if you think about like the IRS, right? The IRS is probably never going to send text messages ever, if we're going to be honest about it. And so they might list their numbers on the do not originate list and say, don't allow any texts through that come from one of these numbers. Of course, when you allow this type of blocking, there is a risk that there could be unintentional blocking or erroneous blocking. And so mobile wireless providers are going to have to appoint a single point of contact, make that person publicly known or that position publicly known, that text senders can reach out to if there is erroneous blocking and get those issues resolved. So it's a familiar concept. It's just not something we've seen in the texting space before. And we'll see where it goes. This, I'm sure, is going to get approved. I mean, at the open meeting.
For sure. And actually, that's a pretty important distinction, right? This is the portion of the document that is the report in order, right? So this is something that they're voting on in a final form versus the notice of proposed rulemaking that accompanied that report in order. And so this proposed rulemaking addresses a few different issues. We're going to talk about two of them today. The first being its proposal to extend their do not call rules to expressly cover text messages. And I'm sure that many of you are thinking, well, doesn't it already cover text messages, right? Don't the DNC rules already cover that? And the answer is sort of. So way back dating to 2003, the FCC has held that the TCPA's auto dialer rules apply to texts. And they essentially treated a text message like a call. And that's how they kind of shoehorned it into the TCPA, which doesn't mention SMS, doesn't mention text message, right? They just kind of treat it like a call. But that was in a very small portion of that 2003 order dealing with the auto dialer rules, where the bulk of the order itself actually talked about do not call and was completely silent on this issue. So kind of interesting context. Separately, they have held that the TCPA's rules also, the do not call apply to calls to wireless numbers. So there's the missing gap here is text messages to wireless numbers. So calls, they've addressed that to wireless numbers, and text messages under the auto dialer rules is they've addressed that. So DNC rules to text is kind of the missing piece here. Courts have deferred to the guidance related to auto dialers and the fact that texts are covered. The most commonly cited case is this Satterfield versus Simon and Schuster case from the Ninth Circuit dating back to 2009. And really what they did is they said the TCPA statute doesn't address this, doesn't define what a call is. FCC has held this, text message is a call, and we think that's reasonable, and therefore we're going to afford it deference. So really, what's the takeaway here, right? Like, that's really what people want to know. For compliance purposes, I say nothing. I think you just should assume that text messages are covered. I think you need to worry about state laws that expressly cover text messages as part of their do not call laws. I think there's substantial risk that a court, although not bound to follow any FCC guidance because there's no guidance to follow, I think that they very well may equate a text to be a call for both do not call and auto dialer. And so I would say just kind of carry on with the status quo. If you are defending against a TCPA lawsuit related to do not call, and we have seen an increase in these recently, given the narrow interpretation the Supreme Court took with respect to what an auto dialer is, I think this provides interesting context. So it's not a slam dunk winning argument, but I think it is something that you can point out to try to argue that the do not call rules don't apply. Even the FCC has admitted they've never ruled on this, and see if you can gain any traction that way. Again, we're looking at that as more of a litigation type of defense these days than a compliance strategy. So,
yeah, and I think, we can feel probably pretty confident that the FCC, once this eventually makes it to a final report and order stage, is probably going to vote it through.
Yep. And actually, that's probably a good time to say that these proposed rules, so they will vote on March 16th of whether they want to approve the notice of proposed rulemaking. That then gets published in the Federal Register. That opens up a comment window of 30 days. And then after that, there'll be another 30 days for reply comments. And then after that, FCC.
There are things hanging out since like 2016.
That's right. That's right. It's really up to the FCC how long they sit on it after that. So
Yeah.
I'm sure there'll be questions is about like, when can we expect this, either because of this or because of the lead gen stuff. They do seem motivated.
Mhm.
FCC does seem motivated to move on these issues. So we don't anticipate them sitting on it for forever, but it has happened in the past, and certainly it's a possibility.
Yeah, and it could take, we often see a delay in the time before it even gets filed in the Federal Register. Sometimes it takes 2 to 4 weeks before it even gets filed in the Federal Register.
Yep.
For the comment window to open, because there's a procedure they have to go through before they actually formally put it in the register.
That's right.
I do think, in addition to just being motivated to deal with what they see are issues,
Mhm.
given we're in the last 2 years now of the Biden administration,
Fine.
they're probably going to be motivated to get this resolved before the end of the term, just in case he doesn't win re-election.
Absolutely. Totally agree. That's a pretty common thing.
Mhm.
So I think those issues are both important. I think those of you on the call are probably to a certain extent interested in them. But I think what everybody is most interested in is the other part of the notice of proposed rulemaking related to lead gen.
Yeah, so I mean, this piece of the proposed rulemaking, I think, has the potential to upend a significant segment of how most businesses collect leads.
Yep.
And how they market their goods and services. So this is trying to close what's been referred to by the FCC as the lead generation loophole. So if you think about the way that many websites gather leads, they do it for multiple sellers using one form, often with a list of sellers behind a hyperlink. I'm sure, you've seen them, certainly we've seen a million of them,
Yep.
right? Where you would have a lead form, you got the consent language to ABC company and its marketing partners. You click the marketing partners link and it takes you to a website that has dozens, if not hundreds of companies listed sometimes. Often not any to do with the actual product or type of product that the consumer was looking for. Like if the consumer was on a website looking for loans, and then there's a bunch of home improvement companies, for example, listed on the list. So what the FCC is trying to do here is they feel, my guess is they feel that it has been abused, and so they're trying to narrow it down. So they're looking to amend the definition of prior express written consent to say that a multi-seller lead form is only valid under 2 circumstances. First, all the sellers have to be logically and topically associated with the website. So going back to the example I just gave of a website for a loan product, it would be probably hard to argue that, say, solar energy is logically and topically associated with a website where someone's looking for a car loan, right? So you're going to have to really think about if you are a company that generates leads for sellers in different verticals, how does that work with your site? And do you maybe need different sites that could collect those leads depending on what the consumer is looking for?
Yeah, I think one of the interesting things there, right, is we've got these sites that really don't relate to anything. It's a sweepstakes form or something like that. And by entering that, you're supposedly providing consent. So I think those are the ones that are probably the low-hanging fruit, right? Not logically and topically associated. And then from that, you start moving away from it. You get forms that have industry verticals that are not really related at all. I think you mentioned loans versus home improvement. That's a good example. And then you're going to start having probably fights over whether this type of financial product or service is closely enough related to this type of financial product or service, right? So there will still be some details to work out, and the courts will have to do that at some point, but it's at least a standard, and at least you can kind of see where their head's at and kind of what might pass muster and what might not.
Yeah. The second condition, though, and I think this obviously poses a challenge, is that those sellers, so let's say you've got a list and they're all topically and logically associated, but you've still got a pool of 50 sellers that you're trying to collect leads for there. Those must be clearly and conspicuously listed on the same page as the form. So this gets rid of that ability, in theory, to have hyperlinks. And Nick and I were discussing earlier today, what does that look like for a lead form? Because there are concepts of clear and conspicuous that have been around for many, many years.
Yep.
And if you look at those, that means probably above the button, not buried in some footnote, having the text large enough that it's easy for a consumer to read, all the things that we think about when we think about clear and conspicuous disclosure. And so I think that's going to pose a challenge as well. One of the other interesting facets of this, though, is Public Knowledge, which is an advocacy group, had made a request at one point in time for the FCC to limit prior express written consent to one seller. So this would get rid of multi-seller forms entirely. And the FCC is asking for comments on that suggestion. And obviously that would be a real upend for a lot of businesses.
I think you can read between the lines a little bit. I think they see the value in a comparison shopping type of site. I'm interested in this product, and then being connected with people that provide that type of product or service. So I think that they see the value in that. And I don't think they will go as far as Public Knowledge requested them to go. I think this is kind of their balancing act. And they've also asked for alternatives to that, right? So they have a proposal. This is actually, they've proposed amendments to the text of the regulations. And that's would do the two things that we just mentioned. They say, is there anything else that we could have done or should have done? Should we do this one seller form rule? And so I think this is going to be industry's opportunity to push back a little bit, maybe try to come up with some type of a compromise. Maybe it's limiting the number of sellers that can be behind the hyperlink. Maybe it's limiting the number of sellers that you can actually sell a lead to, so that these individual consumers aren't bombarded with calls from 100 different companies, even if they are in the same industry vertical, right? So there might be some ways to push back on that. The FTC years ago, and the FTC, it's a different agency, but they have historically been the one that talks about what is clear and conspicuous. They have decades long guidance and precedent on this. And they published something called the .com disclosures document years ago. And basically it addresses many different things of how you make disclosures in a digital world. But one of the issues was hyperlinks. Can you put disclosures behind a hyperlink? And their general rule was no, if it's a integral term to whatever it was like an offer, you couldn't put any type of integral disclosures behind it, but you could put some of the smaller, less important details back there, as long as the hyperlink was clearly visible as a hyperlink and properly labeled. And that's what a lot of companies have tried to do with the marketing partners, right? We understand what's on the other side of the link, at least to a certain degree. We may not understand it's 1,000 companies, and we may not understand that it's all these different industry verticals, but we understand there's the company names there. So there's maybe an opportunity to push back a little bit on that. I'm not sure they're necessarily going to cave on that issue, but I think it is something that seems a little bit more realistic, obviously, than trying to get them to scrap the entirety of this logically and topically related issue. So we have had questions. We'll get to those in a minute, but just kind of broad brushes here. People are interested in like, well, what does this impact, right? The auto dialer definition is really narrow now, and I'm probably not using an auto dialer for calls and texts anymore. So what do I care about written consent? And so I think the answer is a little bit multiple. The first, pre-recorded messages. Anybody that's actually doing pre-recorded marketing messages, you have to have written consent. That's for both calls to cell phones, also residential numbers, would include things like ringless voicemail, includes things like soundboard technologies, avatar, etc. And so that's the obvious impact. But the other one is the do not call rule. So if you remember, in order to call a number that's on the National Do Not Call Registry for a marketing purpose, you have to have a valid exemption. And the valid exemptions are written consent or an established business relationship, or EBR. And an EBR can be based on either a prior transaction, which isn't really what we're talking about here, or it could be based on an inquiry. So somebody can inquire about your goods or services. And so really the idea here all along has been, let's get written consent, because that's going to cover the auto dialer issue. That's going to cover The do not call issues is going to cover any state nuances that there might be. And that's still likely what your compliance strategy should be. The inquiry EBR issue, people are saying, well, if they're asking about home improvement, then they've inquired about our products and services, we should be able to reach out to them. The FCC has never taken a position on this. The FTC has years and years ago, I think it was 2006 maybe, and they evaluated one of these industry specific kind of financial services lead gen models, and they said, no, we don't think that creates an inquiry EBR. We ourselves, FTC, won't pursue enforcement as long as you meet like some of these criteria that we're going to list. But that doesn't stop a court from applying the TCPA. It doesn't stop a plaintiff's attorney. It doesn't stop a professional plaintiff from pursuing companies for those types of issues. So I really think that we're talking about do not call risk here under the TCPA first and foremost. And that's manually dialed calls. That is anybody whose number is on the DNC list. So you can see the scope of this. We're not just talking about pre-recorded messages or auto dialer calls. We're talking about any marketing call and whether we have a valid exemption. And the other thing is we now have these states that have their mini TCPAs. A lot of them have been around for a long time, but the newer ones have started to really focus on written consent requirements that piggyback what the TCPA requires for pre-recorded messages and auto dialer calls and texts. And so their definitions match the current version of the TCPA. If the FCC amends their own definition, it's not going to amend the state's statutes directly, but it could do two things. One, it could impact new states that are currently considering doing this. And second, it could impact just how they interpret what is written consent. So even if the definition doesn't say it has to, these limitations apply, a court could always apply them if it chooses when interpreting what is valid written consent. And so I see that as being another potential impact here. And the other thing I just don't want people to lose sight of, and we'll get to the specific questions people submitted, is we also need to understand that even if these two changes are made, there are a lot of other things that you need to think about when it comes to lead gen forms, right? The FTC has been very active in enforcement, mostly on the pre-recorded side, but to a certain extent on the do not call side. And they have said very specific things behind closed doors about what they think a valid lead form is. So there are certain practices they've taken issue with, things like very small disclosures that are not just below the button, but maybe even like outside of a box that the form that represents the form. So you wouldn't even see that there's anything there. They've taken issue with the lack of contrast between the background and the text. They've taken issue with the language that's on a button if it's misleading, so that somebody doesn't understand what they're doing, the significance of clicking the button, those types of things. They've talked about a few of these things publicly too. I think they did it at a PACE event that we were at. Louis Greisman did that. But they've also really made a lot of these claims and arguments as to what's valid consent and enforcement actions that our firm and others have been part of. And so we have to understand that even if the FCC does take these steps to do that, we also have to worry about some other areas of lead generation, just make sure that we're mitigating risk to the extent that we possibly can.
Yeah, and I think, context is always key.
Yep.
And, we certainly get requests from clients a lot who say, well, I just want the word, just give me the words and I'll put them on there. But the like you were just saying, when you're getting into placement and color and size and how a button looks, it really is important to look at the whole flow.
Yep.
And look at where the language sits, look at how it's presented, really look at it all in context. And so I think that's going to become even more important with the FCC's proposed changes here. But it's already a very important thing. And so to the extent that any of you watching haven't had someone look at your forms really in context in a while, that could be worth doing.
It is, and it's just so right. I mean, you have to look at it as what would a reasonable consumer think is going to happen when I click this button or register for this event or product or whatever it might be, whatever action they're taking. Do they understand what's about to happen? And just understand that a reasonable consumer standard may not be quite what you think it is. You might think of more advanced, kind of sophisticated consumers, business people, things like that. They don't view it that way. Regulators and courts view the reasonable consumer on a much different level. And so you really have to make it very clear what's going to happen to get their written consent, to get their informed consent. So,
yeah. And we're not talking privacy today, although we will probably in the next month or two have a webinar on some privacy issues, but this dovetails with dark patterns.
Absolutely.
Right. And we've been seeing in the privacy world a real push to get rid of dark patterns, and those same sort of concepts come into play.
Yeah, and dark patterns, for those that aren't familiar, it's just a term that's been thrown around the privacy world to talk about the intentional setup of an enrollment process, a form, or some other website or consumer interaction to get the individual to take the steps that you want them to take without really understanding what's going on. And so, as Josh mentions, this is a really, really hot topic in the privacy world. They're supposedly giving consent to all these practices that they don't really understand what it is that they're consenting to. It's the same issue here. Are we getting consent that they understand? Is it meaningful? And so this has always been a risk, kind of a risk analysis for companies that are either doing the lead generation or, buying leads and calling them or texting them. And it's always a balancing act between trying to come up with something that works just from an economic standpoint, but also checks the boxes that we wanted to check to comply with the laws and to mitigate the risk that way.
Yeah.
I don't think that is ever going to change, but what this might do is shift where the acceptable level of risk on the spectrum is. And so we'll keep an eye on this. Like we said, it's going to be at least 60 days of comments between the initial comments and the reply comments. None of that starts until it's published in the Federal Register. As Josh mentioned, that may take some time. So anybody looking for an answer on this anytime in the very immediate future, you're going to have to be a little bit more patient than that.
But take advantage of the comment window, right? I mean, that is your pretty much one opportunity to get your voice out there to the agency on how this could impact you and how this could impact your employees and your business overall and the broader macroeconomic impacts, right? Help the agency understand the repercussions of this. And if you've got an idea, give it to them.
Yep. And you can either do that directly through your company. You can do that through signing on to maybe an association that might be filing comments. There's multiple ways to do that, but I agree, this is the chance to be heard. And I think you have to be realistic when submitting those comments. I think if you try to attack things like the logically and topically associated standard, that's not going to really have much of a chance to succeed. Whereas if we really push back on what's clear and conspicuous, and is there any circumstance in which we can use a hyperlink that might make it a little bit cleaner, perhaps there's some movement there where we can get a compromise. And so that's the things that I would be focusing on.
Yeah. And before we turn to the questions here, just because you mentioned organizations, I think I can say this without speaking out of turn, that PACE, the Professional Associations for Customer Engagement, is putting together a coalition to develop comments. So if you are a PACE member and you would be interested in participating in that comment process, feel free to reach out to me or to Michelle Schuster, for those of you who know her, and we'll be happy to link you up into that process.
Great. Yeah, well,
right.
Let's dive into the questions.
Let's dive into some questions, and thank you all for quite a lot of questions.
Yeah, we have a bunch of pre-submitted ones. We'll go through those. Anybody else that wants to submit a question, like we said, feel free to use the question and answer function through the system. So why don't you go ahead and take one?
All right, so we'll just take the first here on the list. Do you anticipate these rules having a significant impact on what this person called already compliant first-party senders? Here's what I'm going to say. What you think may be compliant today may not be compliant once this passes. The way that forms are constructed is obviously a matter that I think you're going to have to look at. So even if you feel you're already compliant today, it's worth looking at.
Agree. I mean, it also depends on what you mean by first party sender. If you're talking about you're the seller and it's your website and you have your own form, your own lead form on that website, then this really doesn't have much of a direct impact, at least not the lead generation loophole part of it, right? Because you're not generally getting consent for multiple senders or sellers, you're getting it for yourself. And you wouldn't have a need to link to a bunch of different other sellers. So I think the impact is pretty minimal on somebody that's hosting your own form and getting consent that way. That being said, remember what I said about the FTC and the way that you're using the form. This isn't the only issue that you need to weigh when you're analyzing whether it's going to provide valid written consent or not. Goes back to your statement about compliance, whether it's really compliant or not.
Right. Yeah.
All right. Next question. Does this apply to ringless voicemail? Some ringless voicemails also send text as part of the same flow. Is consent implied if somebody calls from a TV, radio ad and follow-up text are sent? So there's kind of a couple questions there. On the ringless voicemail, that is generally a pre-recorded message and should be treated as such. So yes, it's going to impact those. That's the written consent issue that we talked about. Then as far as the text rules, that would be if you have a text attached to that in terms of the flow and the cadence. That would potentially be the whole do not call issue that we talked about. That would potentially be the text blocking issue that we talked about. And that would also be this lead generation loophole, right? You wanting to get some type of a consent so that you don't have to scrub against the national do not call registry.
Oh.
On the TV radio one, I think what they're asking about is a lot of retailers or other companies that have some type of call to action, and then you text a keyword to a short code to opt into the program. And those can be set up in a way that is, provides strong arguments that they're valid written consent, having the right language in the call to action that solicits the inbound code. Oftentimes companies will use a double opt-in just in case somebody ever says, well, I was just told by some business representative to text this, especially if it's like retail or something like that. Oh, they just told me I could just text this keyword to this number. I didn't understand. So they'll do a double opt-in. So once they get the initial text, they'll have the language again, all the TCPA written consent language, and have them opt in again. That's another way to do it. So these issues about multiple sellers and links and all that, I don't think really impact that type of opt-in. But again, it's always critical to make sure that you're setting up the program in a way that provides the valid written consent.
Yeah. All right. How do these changes impact campaigns where you manually dial, and what happens after the 30-day period for comments? So we talked about what happens after the comments. So that's already been addressed. But as for the manual dial, remember what we were just talking about with DNC rules. So even if you manually initiate a call, if it's for telemarketing purposes, the DNC rules apply. And so the prior express written consent changes could have an impact, because that could impact that written consent portion of the two exemptions to having to do DNC scrubbing. Also, I am aware of some systems that allow you to manually send pre-recorded messages. So if click to dial systems to initiate pre-records. So if you're using a system like that, obviously it's still gonna have an impact.
Yep, absolutely. The next question asks how this will affect, and it lists several well-known lead generators, kind of in like home improvement and real estate spaces, and how they're matching consumers with the sellers. And really, I think it's all what we talked about already. It's that if they are doing this, their form has to be such that every seller is logically and topically related. Now, again, we don't know the exact outer boundaries of that, but if they're interested in a particular type of home improvement project, they should be providing consent to companies that provide that type of home improvement project. So I think I would err on the side of caution probably early on until we kind of get a feel for how broad that gets, that ends up being interpreted. But I think it's going to impact everybody. I don't think it's just those types of lead generators. I think everybody, at least, overwhelmingly, it's going to impact them. So I don't think you should assume that just because there's a company that's well known or very large, that they're not going to have to make changes to their business model to accommodate what the FCC is proposing here.
Yeah.
All this is a contingent upon it passing, of course.
Right. Yeah. Is there a do not text list like a do not call list to register for? And how does EBR factor into these rules? So there isn't a separate do not text registry. There's just the federal, and then about 12 states have their own state do not call registries. There's not a separate one for text messages. And then how does EBR factor in? Well, I mean, it kind of doesn't, depending on what your issue is. If your issue is do not call, then EBR could come into play as being one of the exemptions, right, to the do not call scrubbing. If your issue is pre-recorded messages, then EBR doesn't really impact that. So it really depends on what the underlying issue is.
And also what the underlying campaign is, right? So if you're trying to text people with whom you've done business with, right, you have that type of transactional relationship with them. That's one way that to trigger the EBR exemption. If you're talking about an inquiry on a website and this whole lead gen issue, I think it's a different story, right? We would prefer to go down the consent path than the inquiry path, just based on what's out there today in terms of federal laws and whether a third-party web form creates an inquiry between the lead buyers and the consumer. Okay. What does your gut tell you about where the FCC is going to land in relation to hyperlinking to partners if they're all in the same vertical? And do you think they'll provide any guidance on how many is too many? So I think what this gets at is a little bit what we talked about, which is there a room here for a compromise? And I am hopeful that there might be some room here. I do think this FCC, as currently constructed, is pretty consumer friendly. I think they're pretty aggressive on these types of issues. So I think assuming that they're willing to compromise is probably a little bit too much, but I think there could possibly be some middle ground here. I think that there are really strong arguments as to why an industry specific lead form that limits the number of sellers that could maybe purchase a lead or be listed behind the hyperlink or both might be something that is doable. And then how many is too many? I think that's way too early to speculate as to that. But in terms of how many that might call, the FTC spoke to that a long time ago in that one staff opinion I mentioned earlier, and they said that they wouldn't take enforcement if you limit it to a reasonable number, and it was something like 3 or 5 is generally what the industry ended up doing after that. So those of you that have seen the language says you agree to be called by up to 3 or up to 5 of these lenders, something like that. That all stemmed from the FTC's staff opinion in 2006 that we mentioned earlier. So.
Yeah, I may have just lost all hope that there's room for compromise, but I hope I'm wrong.
Yeah, I have not given up hope yet, but we'll see.
All right. Will there be more registration processes around SMS similar to the campaign registry? And then a couple other questions here. How do carriers come up with risk ratings for phone numbers related to texting? So this is a little separate of an issue. The campaign registry was not something that was created by the FCC. That is something that was created by the wireless carriers to help police the text messaging ecosystem, because that ecosystem is a lot less regulated from a pure FCC standpoint under the Communications Act than voice service is. And the campaign registry, requires text senders to register campaigns in order to get access to the bandwidth that they probably want, and to reduce the risk of messages being blocked because those campaigns have been registered, which enhances the likelihood that they're trustworthy campaigns. The proposed do not originate list and the authorization to block texts that are highly likely to be illegal probably won't have a significant impact on how the campaign registry functions or how carriers work with regard to campaigns that are registered. I highly doubt that the carriers are going to want to set up another registry system since this one exists.
Right.
They may make some tweaks to it or something like that to do a little extra due diligence, but I doubt they're going to set up a separate system. And as for how those risk ratings and those blocking decisions are made, I mean, it's essentially a black box.
Yeah.
Every carrier has its own partner analytics company that it works with, and they factor in a whole bunch of different data, and they look at text patterns and words that are used and how often words are used and all sorts of different things to come up with those risk ratings. And of course, they consider that highly confidential and proprietary. So if you can get a Haya to tell you how they do it, I'd love to hear it, but I know they certainly have always rebuffed my questions on that. So
No, but I do think that underscores what you mentioned earlier about having a way for callers and texters to dispute maybe the blocking or labeling as it might be.
And those processes already exist. They're just not well structured in the text world. In the calling world, every carrier has to give that single point of contact. But in the text world, it can be a little messier trying to get those things fixed. We got.
Yeah, I'm going to do the one here that somebody submitted. I thought it was an interesting one because it kind of hits at the heart of what we talked about, which is, what are your initial thoughts on logically and topically associated when it comes to education opt-ins on a job site? So I think this is a good example because it's really applying a standard to a specific situation. Now, I would say the facts, like what does the job site look like? You know, what's the education that's coming off of that might be, but we do know that at least certain lead gen sites, job sites in the past that were used to generate leads for education had been questioned by the FTC. In their mind, it wasn't clear at all that this person was providing consent for these types of educational opportunities and the companies that provide them, whether they're for-profit or nonprofit institutions. So I think answering that with a definitive conclusion is challenging. I would just say that education is tangentially related to jobs. And so I could see an argument being made there, but I certainly wouldn't say it's black and white. And I would say that that's some type of risk analysis that would have to happen. Again, context matters, right? So if the flow on the job site makes it clear that like, hey, we are going to try to get you information on available jobs, and to the extent that you're interested in that, with people who provide additional education opportunities that could also help you along your way. If that's all very clear to the consumer as they go through it, then I think the answer to whether it's logically and topically related is very different than if it's just a job listing. That's it. You register, you see the job listings, and now all of a sudden you're getting called about educational opportunities, right? Those are very different scenarios. So this is a perfect example of why facts matter and context matters.
Yeah. Well, and I think that goes along with one of the other questions that we got, which is, how does this relate to real estate and construction services for new home buyers? And I think it's a very similar sort of analysis, right? As a new home buyer, you may need some work done on your house. You go on a website that may offer all kinds of different construction services.
Yep.
But if you're going down a path that says, I'm looking for plumbing, and then all of a sudden you're getting called by electricians, that's potentially an issue, right? And so that's where these really understanding the flows, really understanding what the consumer's looking for, and making sure that those align is going to be getting a lot more focus under this proposal.
Yeah, I'm like envisioning a website that, and I've seen these out there to a certain degree, but you're a new homeowner, whether it's your first home or not, but you just moved. And so you need to set up, phone service for anybody that still has a landline phone. You need to set up maybe home security. You need to set up.
The internet might be a more.
Internet's
more
probably
apt,
a better one. Yeah, exactly. Whether it's maybe you're still doing cable satellite, maybe not, maybe we cut the cord, but in any event, you have a bunch of things that are relevant. And so there are sites out there that might say like, hey, we can be your one-stop shop. And then you indicate all the different things that you're interested in. And then once you've indicated that, you're connected with those, but only those people, right? Not necessarily every other type of seller that the site might also generate leads for. And so I think that, the industry is going to have to be creative. I think there are solutions to a lot of these things. I think it's just a matter of finding a way to get people interested and get people to make certain selections, create forms that are related to the website itself and the consumer's interests, and then connect them that way.
Yeah, and you know, from a business standpoint, I've heard some people, you know, that I've spoken to since this first broke, who have said, well, you know, this may actually be a good thing for a lot of lead generation companies because it's going to push people to really focus on high intent and also high value leads,
Yep.
right? So, you know, you may generate fewer, but they're leads that you can charge more for because they're the people who have expressed a very precise interest in that good or service.
Absolutely. Okay. Well, I think that's all the questions that we have for now. Really appreciate everybody taking the time to join us today. I think we will have a copy of this available on our website at some point. Not sure on a precise date. So,
Once the editors get done with it.
so check back for that. And if you have any other questions, feel free to reach out to Josh or I. Always happy to speak with you. And if not, we'll see you at the next webinar. So thanks, everybody.